The doctrine of the separation of powers is one of those theories. It's often mentioned, but often forgotten. But not here. From this video onwards, we are going to dive into the three branches: the executive, the legislature, and the judiciary. And we will look at each one of them in detail. And we are also going to learn how they operate here in Australia. However, before getting there, we have to understand the reasons for its existence. Hello everyone, my name is Renato Costa, this is AussieLaw, and today we will look at the doctrine of the separation of powers, the principles behind it, and its general application here in Australia. The origins of the doctrine of separation of powers is generally associated with a French lawyer called Charles-Louis de Secondat, the Baron of Montesquieu. People just call him Montesquieu. He wrote a book called L'Esprit des Lois, The Spirit of the Laws, in 1748. That's the place where most of the references regarding the separation of powers comes from. But, truth be told, this idea of splitting powers into different areas came way before Montesquieu. For example, in the Christian Bible, God had divided society into kings, prophets, and judges, and each one was kind of responsible for a different area of the Hebrew society. And Christianity has also given us the doctrine of the Trinity, which says that God is one, but is divided into three: Father, Holy Spirit, and Son. So they are three, but they are also only one. If you transpose that thought to the state, taking out the faith elements, you can actually see that the idea, the principle behind it is the same. It's about maintaining a coherent unity, the state as one, but also allowing it to be divided and managed by three different branches, three powers that, although they are distinct and different, they're still one. So in a nutshell, this is the theory that is attributed to Montesquieu, that the state exists as one consolidated unity, but it is divided into three branches: the executive, the legislature, and the judiciary. The justification for this separation is to prevent the concentration of too much power in only one of the arms of government. So the doctrine consists of this horizontal division of powers that can guarantee the checks and balances between and among the governmental branches. So the reasoning behind the doctrine is to prevent abuse of powers by one of the governmental branches. This means that each branch has their own limit, their proper function, and therefore they can check each other, they can limit each other according to their own functions. That way, they avoid one interfering in the business of the other. That's why Montesquieu said that each one has their proper function. And look, this is very important, because for Montesquieu, each branch has their own function. That is, they are strictly separated. The three branches are completely, strictly separated one from the other. The judiciary is meant to judge, the legislative to legislate, the executive to apply and maintain the laws. But Montesquieu wrote that in the 18th century. And a lot of people understand today that it's kind of impossible to limit each one of the branches in that way, to have such a strict separation of powers. Because of the complexity of our society, some people don't refer to this doctrine as the separation of powers anymore. They call it the division of powers, because the branches have now typical but also atypical functions. Let me give you an example here from Australia. There's something called delegated powers. This is a possibility of Parliament giving powers to the executive or other bodies to make laws. So it is the possibility of Parliament delegating legislative powers to other bodies so that these other bodies can actually make laws. This has been recognized as a possibility at least since 1931 in a case that the High Court decided called Dignan. In this case, in Dignan, the High Court said that the legislative powers need not be completely separated from the executive powers. So basically, Parliament could delegate lawmaking powers to the executive, and it can do that at least since 1931 here in Australia. This possibility was also mentioned by Justice Fulliger in the Australian Communist Party case of 1951. So, the executive can legislate if it receives some delegated powers from Parliament. And that means that the executive is exercising a function that is typical of the legislative power, but it is exercising this function atypically. That is, it's not their primary function, but it's possible for them to do that as well. And this is why we call it today the doctrine of separation of powers, the doctrine of a division of powers, because we do consider that each of the branches have not only their typical functions, but also the atypical functions as well. And since we are talking about Australia, let's see how this doctrine is actually applied here. The first thing that you should know is that there's no express reference to the separation of powers in the text of the Australian Constitution. The emphasis given to this principle is mostly given because of the structure of the Constitution. As you know, Chapter 1 talks about Parliament, Chapter 2 about the executive, and Chapter 3 about the judicature. The second thing that you should know is that, according to that structure, we do have the three branches of power here in Australia. You can check a little bit about them in the video I've made about the Australian Federalism Explained. Click there and watch that video too. But let me summarize that to you. In the federal level, we have the legislature, Chapter 1 of the Constitution, and it's divided into two houses, House of Representatives and the Senate. And this is the composition of the legislative power that will be exercised by parliamentarians who are elected by the people of Australia, that means the House of Representatives, and the people of the states, the Senate. I should also add that according to Section 1 of the Constitution, the Queen and the Governor-General, there are also elements of the federal legislative power. The Queen and the Governor-General are also part of the executive. Most of the provisions related to the executive are in Chapter 2 of the Australian Constitution. The ministers were also part of the Parliament. They will form the majority of the Parliament and they will become the government. They are also part of the federal executive as well. And although the Constitution doesn't say anything about this expressly, certain constitutional conventions tells us of the existence of a Prime Minister. That's the leader of the government in practice. So the Prime Minister will also be an element in the executive. We will talk about this later on when we specifically discuss the executive, and we're going to talk about the text of the Constitution and the constitutional conventions about the executive. And finally, we have in Chapter 3 of the Constitution the judicature, where we look at not only many courts, but especially the High Court of Australia. If you paid attention in this whole scenario, you can see that yes, according to the structure of the Constitution, there is a separation of powers, but this separation is not really that strict. So this is the third thing that I want you to know. Actually, let's call it 3A, because I'll make an addition by the end of the phrase that I'm about to tell you. There is no strict separation of powers in Australia. Take the Queen and the Governor-General. They are both part of the executive and of the legislature. So they both make laws and also apply and maintain the laws. And the same goes with the ministers, because the ministers are also members of Parliament and are the ones that form the government. They are responsible for making the laws and for applying the laws. And we have here in Australia a principle called responsible government. This principle dictates that the executive, the ministers who form government, will be accountable to Parliament, to the rest, to the remaining parliamentarians that are sitting in the federal Parliament. My next video will be about the principle of responsible government. You really don't want to miss that. So please subscribe to our channel and hit the bell sign, because if you do that, you're gonna be notified when I upload my new video, and you're not gonna miss the video that I will do about the principle of responsible government. And there's yet another thing that I could add here, because the Governor-General, as the representative of the Queen, is also the one responsible for appointing the justices in the High Court of Australia. So we have a member of Parliament and of the Executive appointing a member of the Judiciary. Do you see how these powers are overlapping? It's really hard to see this strict separation of powers in Australia. That's why 3.A tells you that there's no strict separation of powers in Australia, except for the judicial power. That's the fourth thing I want you to know. So let's call this 3B, because at the federal level, the judiciary, the federal judicial power, is strictly separated from the other two branches. So this is something quite unique about the doctrine of the separation of powers here in Australia. Because we adopt here in Australia a parliamentary system, the Westminster system, we basically blown the separation between the Parliament and the Executive. But in Australia, at the federal level, there is still a strict separation of judicial power. And this specific separation of judicial power has been confirmed by the High Court several times in many cases. I could cite some older cases like the Wheat case, Alexander's case, but the primary one is called the Boilermakers case. In that case, we can identify what is a judicial power, how can we characterize this federal judicial power, and how this federal judicial power is strictly separated from the other two functions of government, from the executive and from parliament. So, in Australia, we have no strict separation of powers except for the federal judicial power. And here, what I'm saying, federal judicial power. Here's the other thing that I want you to know. Aspect number 5 is that there's no separation of powers at the states level. The separation of judicial power only exists at the federal level. It does not exist at the states level. If you want to understand more about that, I invite you to read the case called Cable. I will obviously make a video about all of these cases, but until I do, it is a good idea for you to read them. So I left a link to all of these cases in the description of this video. And basically the Cable Doctrine explains the inexistence of this separation of powers at the states level. So from today onwards to the rest of your life, you are going to remember that in Australia, although the Constitution doesn't say anything expressly about it, we do recognize the implementation of the doctrine of the separation of powers. In this sense, we have the three branches, the executive, the legislature, and the judiciary. But we also acknowledge that two of these branches, the executive and the legislature, are so connected, they intrinsically intertwine, especially because of the Westminster tradition. That is why we cannot say that we have a strict separation of powers in Australia, at least none in the Montesquieuian sense. On the other hand, we do know that there is a strict separation between the judicial power, the judiciary, and the other two branches. Federal judicial powers are only exercised by judges and courts according to Chapter 3 of the Australian Constitution. And additionally, we only refer to the separation of powers at the federal level, because there's no application of the doctrine of separation of powers at the states level here in Australia. So now you not only know what is the doctrine of the separation of powers, you also know its application here in Australia. So if you like this video and if you like the videos that we've been producing, please subscribe to our channel and like this video, like all of our videos, and share them with everyone that you think will be interested in learning more about Australian law. And if you don't want to miss any of our videos, click the bell sign. I hope to see you again very soon. Until then, ciao.